Hello and welcome on the Scale of Justice on the Nigerian Television Authority, the NTA. This edition will feature the advocacy for the amendments of some provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended. On the decision from our various courts, the federal government and the former Chief Justice of Nigeria, Justice Walter Onoge, have agreed to settle out of court on the matter on appeal before the Abuja Division of the Appellate Court. These and more will be coming your way on the Scale of Justice. Welcome on the Scale. Dele Atumbi is my name. One of the provisions of the ground is the joint ticket between the governor and the deputy governor. This joint ticket, based on the deficiency of the deputy governor-elect, affected David Leon, the then governor-elect of Bayelsa State, going by the decision of the Supreme Court a day to his swearing in. The president of the Court of Appeal is advocating an amendment to the principle of joint ticket as enshrined in Section 187 of the Constitution of the Federal Republic of Nigeria. The Scale speaks with a member of the INABA, James Igwe, SAN, on the proposed amendments in the ground norm.
Joint ticket, what affected the deputy governor affected the governor. That was the decision of the Supreme Court on this matter. Taking a look at it from that point of view, the Court of Appeal is proposing that whatever affects the deputy governor should not affect the governor. So what is your opinion about it?
Before we get to that, thank you very kindly for starting from a settled position of the law, which is that the Constitution of the Federal Republic of Nigeria as amended is the ground norm, meaning that it is the foundation of all laws. It is from that law that every other law derives its validity, meaning also that if any law is inconsistent with the provisions of the Constitution, that other law is, to the extent of its inconsistency, void. And if any act, if any norm is inconsistent with the provisions of the Constitution, that act itself is void. That was why the legendary Londoning, in the case of UAC and McFoy, stated that if an act is void, is in law a nullity. Because it's like putting something on nothing and expecting it to stand. It certainly will collapse. And then you have that by also Supreme Court of Nigeria in a plethora of cases. And then you can find that also in several cases in Nigeria. And if you look at Section 1, subsection 3 of the Constitution, it actually provides that this Constitution is supreme. And every person, every authority in Nigeria is bound by the Constitution. In the case of AG, Bendel State and AG of the Federation, case of Yusuf and Obasanjo, and several other cases. That is one settled principle. So if any other law, and then I can see the angle that His Lordship, the learned President of the Court of Appeal, His Lordship, the Honorable Justice Monica B. Dongba Mensah, Commander of the Federal Republic, Justice of the Peace, is coming from. Because when you apply Section 1, subsection 3, you would find that some provisions of the Electoral Act, like paragraph 27(1), I don't know how that found its way back to the Electoral Act as amended 2022, which still provides that the chairman of the Election Petition Tribunal can hear interlocutory matters when Section 285, subsection 3 and 4 of the Constitution is very clear on constitution of the tribunals. So that is what we also have to look at. And then looking at also another tried principle of law, let's just put it in proper perspective, because by the time we are torn with these tried principles of the law, it will answer every other question that you have raised. And then the next one is that the Constitution is sacrosanct. Time set by the Constitution is like the rock of Gibraltar that cannot be moved. It cannot be elongated. It cannot be expanded or extended or in any way extended beyond the limits or boundaries of the Constitution. So the Constitution itself remains supreme. If you look at the case of Marwa and Yako, that was what the Supreme Court decided in that case. Now, when you look at our preamble to our constitution also. I want you to have this in proper perspective so that whatever we do in this nation, whatever proposals we are making to amend the constitution, we must remember the clear objective of the constitution. We must remember what Nigerians set out to very beginning. We say to give to ourselves a constitution that will make us an indivisible and indivisible sovereign nation under God. Meaning right from the very beginning, we are aware that there is a God in heaven that we believe in, that will hold us accountable for whatever we do. However we treat our citizens, however we treat our elected or non-elected officials, however we take on amending the constitution, whether it's for a national interest or it's for a sectional interest, that there is a God in heaven, a sovereign God, that we're a nation under God that will hold us accountable. And then there's another thing in the preamble that we must always not forget. We talked about the purpose of providing a constitution for the purpose of promoting the good government of Nigeria, of our country, founded on the principles of freedom, equality, and justice. Freedom, equality, and justice. So will whatever amendment we intend to make, will implementation of any aspect of the Constitution, and even adjudication on the Constitution, is it one that will bring justice? No wonder, Dele, the same legendary Lord Denning, in his treatise on the road to justice said, and I quote from my head, that when you set out on this road, you will remember that there are two great objects to be attained. One is to ensure that the laws are just. Are we trying to ensure that our laws are just? The other is to ensure that the laws are justly administered. All are important, but if you ask me, I will say that the more important is to ensure that our laws are justly administered. You would find that most of the proposals need not be, because in most of the cases we already have very solid laws that only need to be administered by non-corrupt officials. So, I'll now get to your question. That was on section 187 of the Constitution. Remember that if you go back a little backwards, because you're taking the states differently, the same applies to the Federal Republic of Nigeria. Just like section 131 created the post of the president that exercises the executive powers, so the section 1761 of the Constitution create the position of the governor that exercises the executive powers at the subnational level. Just like section 1361 provided the rationale for creating the office of the president, you'll also find section, and also section 136 and the 137 provided for qualification and disqualifications of the governor. You also have sections 177 that also provided for the disqualification of the governor, okay, which also is tied to the deputy governor. You also find there are same rationale in section 1811, which applies to your question on that of the governor, because it provides that when a governor is elected, and if that governor dies before he subscribes to the oath of allegiance to the nation, that the person nominated as the deputy can take over. That was a constitutional amendment which became imperative, if you remember the old case in from Kogi State. Now, the Constitution is very clear, and then related to the federal level from your Constitution is section 142. Then at the state level is section 187 on nomination of a governor. It says that a governor shall, for the purposes of his nomination, nominate a member of his party as his deputy governor, and that the election of the governor, where the governor is validly elected, will also mean that the deputy governor is validly elected. And so, because the Constitution had provided for the qualification of the governor, which also the Constitution says that the deputy governor should be similarly qualified. So, it was reasoned in the case you mentioned is the case of PDP, and I think it's Bayokuma Dayi Eremeyo from Bayelsa State, that the toxicity of the deputy governor is itself the toxicity against the governor himself. Well, I will say that because it is a principle of law, Dele, that when you are looking at the Constitution, you should look at the Constitution in its entirety, and no section should be shut to silence, meaning you do not just look at one section and interpret it. You should look at the document as a whole and give it a holistic interpretation. And if you look very deeply in the Constitution, you will find in section 36 of that Constitution on the fact that nobody should be convicted for an offense except that offense is one that is in a written law. So what would you say is the crime of the deputy governor, of a governor who had been qualified under the Constitution? He is qualified under the Constitution and is not disqualified in any way under the Constitution, because the Constitution set the parameters for qualification and disqualification. Governor is qualified under the Constitution. He's a citizen of Nigeria. He's not a bankrupt. Okay? He has not sworn to allegiance to another nation other than Nigeria. He's not bankrupt. He's not been convicted of an offense involving fraud or dishonesty or anything. He's not disqualified in any manner, but someone else who he nominated is qualified. I would say that I agree entirely with the submission of the learned president of the Court of Appeal, His Lordship the Honorable Justice Monica Dongben Mensah, CFR JP, that should be amended. It should be that if a deputy governor is disqualified for any reason based on the fact of his non-qualification, the governor should be able to appoint someone else. And then the House of Assembly, it should be able, because at that time he hasn't been elected, the governor should be able to appoint someone else in his stead. That makes for justice that the Constitution is talking about. Okay? That makes for justice. So I think I agree entirely with that submission that it should be amended.
The amendment is saying that nothing that affects the deputy governor should vitiate the position of the governor of that state. Could you expatiate?
No, what I'm saying is that if you look at the Constitution itself, the Constitution has enumerated the criteria for qualification. If you look at section 177, it provides the qualification for a governor. Okay? So the man is qualified under the Constitution, but his deputy is not qualified under the Constitution. I'm saying that we should separate the governor from that of the deputy governor, because he has not been disqualified by the Constitution. In any event, assuming the deputy governor is disqualified based on the fact that he forged, for example, a certificate. Did the governor forge a certificate?
Definitely.
Is there a crime under the law that the governor has committed, probably committed at the time the governor did not know who the deputy governor was? That is the justice I'm talking about, because if you look at the preamble of our Constitution, it says we should give to ourselves a constitution for promoting democracy, freedom, and justice. Justice to every individual. Justice to every aspect of the nation. Justice to the welfare of the people. Justice to a person who is aspiring to lead his local government, his state, his nation in any capacity. Will this promote justice? It will not promote justice. And if it will not promote justice, we ought not to allow it. That's the point I'm making.
Anti-graft commissions in Africa must collaborate with security agencies to curb terrorism financing on the continent. This was part of the submissions of participants at the 3-day workshop on investigation and prosecution of terrorism financing cases in Abuja. The workshop was at the instance of the Intergovernmental Action Group Against Money Laundering in West Africa, GIABA. The report. The three-day workshop is the convergence of stakeholders in the financial and security sectors, profiling solutions to terrorism financing on the African continent. Participants are of the view that acts of terrorism and terrorism financing have been the bane of rapid development on the continent. The key players observe with concern the evolving threats of terrorism and its financing on the continent. It is a convergence of opinion that without funds and finances that enable the activities, terrorists and terrorist organizations will not be able to carry out their dastardly acts.
Individual and corporate identity management. Individual. The identity of everybody in Nigeria must be seen. Identity fraud must be nil. It must be impossible for one person to be able to open different accounts, or for one person to have an account in this name, have insurance in another name.
These recommendations and immediate outcomes require each country to implement targeted financial sanctions regimes to comply with the relevant UN Security Council resolutions, notably number 1, Security Council Resolution 1267 of 1999, and its successor resolutions, including the Al-Qaeda and Taliban sanctions.
They advocated the need to cut the finance and supply to reduce the activities of terrorists on the continent.
At the NFIU, we recognize that to successfully disrupt terrorist activities and ultimately dismantle terrorist organizations, efforts must be geared towards not only apprehending the individuals who commit acts of terror, but also to tracing and cutting off the funds that fuel their activities.
Stakeholders agreed that by analyzing patterns of transactions, identifying suspicious activities, and tracing funds across borders, government institutions will uncover the sponsors and facilitators of terrorism. For the anti-graft war to be successful, there is the need for all hands to be on deck. Now to another matter. For everything that has a beginning must have an end. This is the story of a renowned professor of law, Muhammad Taufik Ladan, whose tenure as Director General of the Nigeria Institute of Advanced Legal Studies ends on the 30th of September 2024. In this package, we highlight some of his achievements in the area of legal research, which will impact on the judiciary even in years to come.
Every public officer expects to leave a mark and probably exceeds the performance of his or her predecessor. That is for posterity to judge, and for Professor Mohammed Taufik Ladan, his tenure as Director General of the Nigerian Institute of Advanced Legal Studies ends 30th September 2024. With a core mandate of advancing legal research to deepen legal education and practice in Nigeria, the Institute under his watch carried out several research which resulted in a publication of 10 unique law books in emerging fields of law, 16 volumes of 8 specialized journals, 12 articles published in international journals, and books published by Kluwer, Springer, and Oxford University Press, over 20 strategic rules of courts and practice direction for federal and state judiciaries, and a total of 20 policy bulletins for policy makers and training manual guide books for prosecutors and law faculties in Nigerian universities. Throughout his tenure, the Hubert Humphrey USA Fellow has added significant value to advanced legal research in emerging fields of law and capacity building of the justice sector and legal education sectors in Nigeria and Africa, leaving an indelible mark on the institution and the legal landscape. His leadership has been marked by unprecedented success as he connected law education with all facets of Nigeria's socio-economic development through collaboration with international partners like MacArthur Foundation. He was at the forefront of ensuring the members of the bar and the bench were trained in the application of the administration of the Criminal Justice Act 2015 and equally ensured to its domestication in all courts across the 36 states and the Federal Capital Territory. A renowned expert in public international law, Professor Ladan's contribution have been felt globally with 16 authored law books, over 80 published journal articles, and more than 100 presented papers to his credit. He organized several lectures on topical issues germane to the socio-economic and political development of Nigeria.
We are seeing the relationship between law and religion beyond just religious belief, religious worship, because that is the case in Nigeria. As everybody, you talk about law and religion, everybody thinks that it's about your place of worship, and it's also about just your belief system and your children and their beliefs, and religious education. But this seminar is about exploring the opportunities that law and religion is about human dignity, it's about leadership, it's about national and global security issues, it's about law, religion, and workplaces or labor and law relations. So almost every aspect of human endeavor is embedded in the relationship between law and religion.
His concerns range from environmental issues to corruption fights and involvement of the country in international trade, among others.
I have realized that in actual practice, most of our legal officers and legal advisors posted to the ministry are not specialists. They are neither specialists in international trade, nor in investment law, nor in competition law, nor actually in digital trade law. So, and this is an era of specialization. It's not enough to be a generalist, law. Even professors of law are specializing. So, particularly, this particular AFTA agreement, is a very complex and comprehensive, treaty that has other treaties as an integral part of it.
As he concludes his tenure, Professor Ladan's legacy will continue to inspire and shape the future of legal studies in Nigeria and beyond. Professor Ladan's groundbreaking achievements will remain a lasting tribute to his commitment to excellence and his passion for advancing legal education and reform in Africa.
Former Chief Justice of Nigeria, Justice Walter Onoge, and the federal government have agreed to settle the issues in dispute out of court. This forms part of the decisions from our various courts.
The decision of the appellate court followed an information to the effect that the two parties in the suit have intensified efforts to reach an amicable settlement of all issues in dispute. Former President Muhammadu Buhari had in 2019 removed Onogen as the Chief Justice of Nigeria during the pendency of a charge against him at the Code of Conduct Tribunal. However, Thursday's proceeding in the appeal, lead counsel to the former CJN, Ogu James Onoja, Senior Advocate of Nigeria, informed a three-man panel of justices of the appeal court that the two parties are already having discussions on a peaceful resolution of the dispute. Onoja, Senior Advocate of Nigeria, informed the court that the parties had an engagement till September 18, 2024, and expressed optimism that the discussion will be fruitful. He appealed to the court for a 1-month adjournment for final settlement of the issues in dispute. Federal Government lawyer Tijani Ghazali, Senior Advocate of Nigeria, corroborated the submission of Onoja and requested that the matter be shifted forward for a possible amicable settlement. Justice J. Oyewole, who presided over proceedings, directed them to file terms of settlement for adoption when eventually agreed upon. Justice Oyewole heard that the terms of settlement must be documented and filed before the adjourned date for the court to adopt as its judgment in the matter. He subsequently fixed November 4, 2024 as the return date for the two parties. Justice Onogem was prosecuted in 2019 by the federal government on alleged false declaration of assets at the Code of Conduct Tribunal, found guilty and removed from office.
With the decisions from our various courts, we have come to the end of this edition of The Scale of Justice. Thank you for being part of the program. See you next week for another edition. Dele Atulu is my name.